Morning. Please be seated. We're here for oral arguments in cause number CV17-0380, Dabrowski et al. Versus Bartlett. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs, conferenced the case, and are familiar with your arguments. At this point, counsel, you may proceed.
Good morning, Your Honors. My name is Benjamin Gottlieb with the law firm McQueen & Gottlieb on behalf of the appellants Cross Appellees, Bogdan, and Jolanta Dabrowski. As Your Honors have read in the briefs, we're here to appeal a few different issues. One of the primary issues that the Dabrowskis are appealing today is the granting of a private way of necessity under ARS 12-1202 to the appellee cross appellant David Bartlett. And we have a few different strong arguments as to why we believe the court erred as to that finding. The first argument, Your Honors, is that we believe the facts as shown from the trial aptly demonstrate that Mr. Bartlett in this case voluntarily alienated his access. And to fully appreciate that, one must recognize on some level the distinction between when somebody buys real property and does not have access over the seller's land. So a buyer pays the seller money and the seller knows that the buyer is going to need access, versus this case where you have a seller who is in complete control of his or her own destiny, could have recorded an easement, could have bargained for an easement, but chose not to. And as indicated in the brief, what the facts showed here was that Mr. Bartlett bought these two subject lots back in 2003 for $500,000. Less than 2 years thereafter, he sold just the north lot to the Dabrowski's predecessor in interest for $440,000. And he testified at the trial that both lots were of roughly equal value. So here we have a seller of real property who turns a substantial profit through his own conduct of not only not reserving this imposing encroachment, but also, as the evidence showed at trial, through not disclosing a need to the buyer of a need for an easement. And that
you're saying there's no remedy then whatsoever for Mr. Bartlett?
Well, I think in this case he could have sought an easement from the state trust land. He testified at trial. He didn't try to. As we've indicated in our brief, there was a recorded 2003 lot split which depicted an easement providing ingress-egress from the Bartlett lot. Furthermore, the evidence in this case showed that the purpose of recording the 2003 lot split was to enable the sales of the Bartlett lot and the Dabrowski lot to Bartlett back in 2003. And the way we know that was what the evidence showed at trial was that in March of 2003, Jacob, through his engineer agent Ted Luther, applied for a building permit for the Bartlett lot and indicated to the town of Cave Creek that there was no legal access, or he was not aware of any, to or from the Bartlett lot. 1 month later, the 2003 lot split in April of 2003 was recorded, depicting access to the Bartlett lot. Mr. Luther was the engineer responsible.
And the access was through the Anderson lot or through the Hiltner lot?
The access was actually at the midpoint, through the Anderson lot, at the midpoint where the
I thought there was
lot.
Oh, I'm sorry.
Yeah.
I just thought there was testimony that that particular access was actually not feasible. And didn't the trial court find that in fact that easement could not be used?
No, Your Honor, I don't believe she did find that. In fact,
Through the Anderson lot.
Yeah, the Dabrowski's expert testified repeatedly at the trial that he went out and measured that easement, the easement on the 2003 lot split. He was able to identify with reasonable certainty, and he believed that it was a feasible easement where you could construct a roadway over it. Now, there was some discussion, I would argue speculation at the trial, over as to whether the fire department would be able to drive a fire truck over the road, or whether the town of Cave Creek would ultimately allow the roadway, and whether you'd have to widen it to construct it. But there were no findings by the trial court that the easement was not feasible. The trial court rested her ruling on the fact that, based on technical grounds, the 2003 lot split did not constitute an easement. And what the Dabrowski's position is that when we actually explore the circumstances in this case, the 2003 lot split easement is what enabled the sales, allowed the sales to occur, because per town of Cave Creek regulations, before consummating a lot split or recording a lot split, you have to show access to the lots. And that's what this lot split was designed to do. That's what the testimony from trial showed. The lot split was...
It was more than just a technicality. I mean, they weren't signed, and there were other problems with the actual easement, right? I mean, well, you say technicality, but if you don't comply with the law, you don't comply with the law.
Well, we would contend, though, that Jacob, the creator of the lot split, should be stopped from denying the existence of the easement. He was able to sell the Bartlett lot. Bartlett, the 2003 easement was listed in Bartlett's title report, which he admitted at the trial he received in escrow in connection with the purchase of his lots, which showed the 2003 lot split. And so what we have here is and now Bartlett contended at the trial, even though it was in his title report, he had no knowledge of it, and he had no knowledge of any recorded easements. But I think that's what goes to the Dabrowski's point here on appeal, which is if he's not aware of any recorded easements, and he voluntarily, through his own voluntary act, sells the northern lot, and he turns a substantial profit without recording or reserving an easement, the likes of which, from what Bartlett, the easement he's asking for, he probably wouldn't even have been able to sell the lot, let alone the reduction in the sales price. And then now he's in court seeking an equitable remedy of private condemnation. And so, yes, it's our contention there is case law that supports this argument, that if you, through your own voluntary act, you alienate your own access, you can be deprived of even a right of private condemnation. And we believe that reasoning applies here. And
Would it make more sense to just say that you have to adequately compensate the, presumably if you'd put people on notice and there's some price at which that property would have been purchased with an easement through it, why wouldn't that be a good remedy?
The problem with that remedy, Your Honor, in this particular case, these are homes nestled in deep within town of Cave Creek. The area boasts of privacy and seclusion. As both parties concede, we're talking about mountainous terrain here. Privacy is a huge issue, and that's why people move out here. And so now you have a situation where down the chain of title, the Dabrowskis have purchased their lot with no indication that Mr. Bartlett would be knocking on their door asking for an easement, let alone an imposing easement, that now has presented very serious concerns to the Dabrowskis, to the point that not only would they have never purchased their lot, but now they feel like they have to sell it, and they won't even be able to sell it because of the easement that Bartlett is asking for is so close to their home and so imposing. And so I think when we look at all of the facts and circumstances in this case, it warrants a conclusion of law that Mr. Bartlett voluntarily alienated his rights of access here, and compensation won't do justice to the Dabrowski. I understand the trial court awarded.
So you're saying that we should just say those 5 acres are just going to be landlocked forever, and there's never going to be any use for that land?
Well, I don't think that there's going to be no use. He still has options. He can seek an easement from the state land. He can negotiate with Anderson. He can negotiate with the property.
I thought Anderson said no.
He could freely negotiate. I mean, this is no different than the Galata case, where the court basically said we're not going to be awarding private condemnation when you voluntarily alienate your right of access. In the Simpsons case, the court said even though there's this extremely other inconvenient route and you would need an easement over state trust land, we're not going to be awarding a remedy due to the lack of reasonable necessity.
When you said you were going to voluntarily do that, didn't Bartz believe that they had an easement?
He tried to testify to that, Your Honor, but there was absolutely no basis or evidence underpinning his testimony. He claimed he wasn't aware of any recorded easements. He claimed he wasn't aware of the 2003 lot split, which depicted the easement. In the seller property disclosure statement, he did not disclose to Hiltner any such need for an easement. Hiltner or Mahan did not testify at the trial. There was no other written evidence indicating that Hiltner Mahan knew or understood or was otherwise somehow implied from the circumstances that Dabrowski's lot would be granting Bartlett an easement. So really, I don't think you're ever going to have a case where a seller of real property gets on the stand and says, I intentionally landlocked my property, but if you look at all the evidence here, that's what happened. And
I just find it hard. You keep saying intentionally, but I don't. Do you think he really sold that property intending to landlock it, or he just did it negligently?
I think he appreciated the danger of losing access, which is exactly what the Arizona cases talk about. That's the language that they use when discussing this theory, that if you appreciate the danger of losing your access through your own voluntary act, and that's exactly what happened here. Mr. Bartlett was not aware of any recorded access. He's denying that he had knowledge of the 2003 easement, and yet he turns around and without disclosing a need for an easement or reserving an easement, makes a substantial profit on the sale of property, and then is essentially trying to create precedent now through the court where he can turn around the next day and use the implied easement doctrine, use the private condemnation statute as a sword by saying, you have to give me an easement, and if you don't, I'm going to get one from the courts. And that's really what happened here, actually, if you look at the early settlement correspondence, is he used the easement law as a sword. And I don't believe that's the policy behind private condemnation. I understand.
Go back to your statement, appreciate the danger. I'm not sure I understand. What case are you suggesting? Where does that language come from to suggest that somebody who's saying that appreciates the danger that they're not going to have access to their property? Well,
I believe the Galata case said that, Your Honor, which was cited in our brief. Now, I know that case is not exactly factually similar. There was an express negotiation to negotiate away the easement. And we don't have that, but what we do have are circumstances where he testified at trial, he was not aware of any recorded access, and notwithstanding that, he sells the property at a premium, which would clearly indicate that you're not going to be asking for this huge encroachment the next day. The trial court found that the slider easement was almost $100,000 encroachment. And he did it under circumstances where he didn't reserve an easement, he didn't ask for an easement, and none of the other circumstances support that he should have expected an easement. So in our view, he appreciated the danger of losing his access here, which is a slight extension of Galata. We'll admit to that, but we believe that the case law supports that that's what took place here. I understand Mr. Bartlett's position is this was an accident. It's awfully convenient that he almost recouped his entire the money he paid for both lots. He nearly recouped off of one sale without disclosing this incredibly onerous encroachment, and then now is saying one day later he should be able to use the doctrine of either private condemnation or implied easement to get whatever easement he wants.
Let's say it was just a simple matter of an easement through a tiny corner of a 20-acre property, and somebody's made a profit. I mean, the fact that you've made a profit doesn't seem to be controlling if the value of the land's just gone up. But if there's just, you can go through and just take a tiny corner that doesn't seem to have much of an effect on the rest of the property. Under your approach, even that would be out of the question. That would not be something that he could do because he appreciated the risk that he didn't have an easement. And I guess where I'm going with that is, well, first, would you agree in that he's just flat out of luck? Nothing can be done?
So, Your Honor, let me address your question in two parts. First, I think you would need to look at all the facts and circumstances. Was it truly a mistake? Was there truly a genuine misunderstanding? Or is the seller getting on the stand and just saying, hey, I thought I had access without any underlying basis or any other supporting evidence? Secondly, Your Honor, your question segues into another big part of our appeal, which is that if the court is defined private condemnation here, he should not be awarded what is both parties are calling the slider easement. Because to your hypothetical, Your Honor, the slider easement is not on the corner of the parcel. That's more a resemblance of the other two easements, Gram 1 or Gram 2, which the Dabrowskis are contending if they absolutely had to, they would be okay with. The slider easement is very onerous, and the trial judge said in her own ruling that if we're going to give you an easement, it's going to afford the greatest deference and privacy to the Dabrowskis, but then they were awarded this easement, which we contend was a bad faith, oppressively chosen easement as
What would your client's first choice for the easement be?
it would be either Gram 1 or Gram 2, Your Honor. Those are both acceptable if they absolutely had to, although we strongly contend that they do not want one, but those would be the two, and absolutely not a slider, Your Honor. I would like to reserve some time for rebuttal. Thank you.
Thank you.
Your Honors, may I use the
Absolutely.
visual person? And this involves visualization.
And before you get started,
Yes.
I'm wondering, nobody in the courtroom can see what he's talking about.
How would you like me to do that?
I'm not sure if there's any way, any suggestions? Okay. I guess it's most important we see what you're talking about, so.
It'll be on the video.
And I may switch these a little bit to make my point. This case involves access, obviously. Mr. Bartlett came to court after Dabrowski sued him to try and not have him have access. And he had four legal theories available to him. He had the modified express easement, the 2000 modified express easement, which is of record today, which has always been of record, which the Dabrowskis took subject to. They saw it on their title report. They saw it on their title policy. It was on every single person's deed and title policies that is pertinent here. This is the 2000 modified express easement. This is the 2000 express easement. Both of those easements were part of a development of the Rancho de la Hermania residential community. And these two easements were meant to benefit a lot up here, this lot, which is now the Dabrowski lot, and this lot, which is now Bartlett's lot. And the reason they split these lots, this was Mr. Lewis, split these lots like this and put these easements in there so that he could develop these properties. Now the lot split map, I'm going to get to that, jump
They
ahead.
attempted to, because they didn't do it correctly.
Pardon me?
They didn't do it correctly. They weren't properly signed, et cetera.
No, they were. Those easements.
These easements are.
These were. The one that wasn't,
But then they, go ahead.
I'm sorry.
No.
The one that wasn't is this lot split map. This lot split map was created in 2003. This is what they contend was an easement at trial. That's what they contended all through trial. Their own witnesses testified this does not meet the requirements for an easement. This had a description of this easement here. That is this easement here. That's the 2000 express easement. This part was not on the lot split map.
We can't see
I'm
down
sorry.
there.
I'm sorry. This part was not on the lot split map. this part, the lot split map in 2003 showed this. This here is the Anderson driveway. And despite what he says, the evidence at trial did not show it can be constructed. What it showed was that it could not be constructed because it could not meet code, and it probably right now does not meet code, that driveway. And to build it would require such a substantial expense and disturbance that to get to Bartlett's building site that he couldn't build a house. That's what the testimony showed. He might be able to build a shack, but because the town of Cave Creek has disturbance criteria. The more you disturb to build access, the less you have for your building pad. That's why this wouldn't work. The second reason why it wouldn't work is because this is the driveway that's depicted on here. This driveway is a steep, narrow driveway. There's a drop off here along the western edge, and along the eastern edge, it's sheer rock. So you can't make it wide enough to accommodate 2 households. In other words, there's fire code, and there are Town of Cave Creek hillside ordinance codes that came out in trial, that even the Town of Cave Creek's Ian Cordwell testified about, and that experts testified that you have to meet those in order to be able to build a roadway from the top of the Anderson driveway all the way to a Bartlett building site down here or here. And you'd need a substantial, in other words, you'd have to build retaining walls and build the roadway up to meet the hill that you're on, and that would create so much disturbance that you couldn't do it. Secondly, you'd need a disturbance easement from Mr. Anderson, who said he's not going to give it. And he also said nobody's ever used this as an access point for anything except his lot. There's a gate down here that's been there since Mr. Bartlett, before Mr. Bartlett bought the property from Mr. Jacob. Mr. Jacob told Mr. Bartlett, you don't have this, you have something this way. There are easements that are recorded this way. That's what Mr. Jacob told Mr. Bartlett. And for them to say that Mr. Bartlett said he never knew about what his rights were to get access to his property, that's just not true. That was not what was said. And when Mr. Bartlett was asked about a recorded easement, he said, I don't know the number as I sit here today. And that's what he interprets to mean that Mr. Bartlett didn't know about any other easements. That's not true. Now, if you look at the record, after Mr. Bartlett sold the property to Hiltner and Mahone in 2005, that's the first time these 2 lots 1 and 2, were separated. That's the first time you have a severance. That's the first time that this easement is needed. It sprang into effect then. And when Mr. Hiltner designed his house,
and just so we're clear, so when Mr. Bartlett sold this lot to Mr. Hiltner, was there an express easement over the lot that he sold to Hiltner?
There is to this day.
Do you have a record citation that you could give us for that?
Other
than your drawing and your statements here today?
It's trial exhibit. Well, this is trial exhibit 126.
Yeah, but I want a record citation.
I'll give it to you right now. Yes, it is trial exhibit 103.
And that's where there was an express easement?
On March 9th, 2000, a declaration of easement was recorded.
But then the lots were combined?
No, the lots were always in one ownership.
Okay.
They did.
Because I know that. When did Hiltner get his lot? What date?
This lot was transferred to Hiltner in 2005.
2005.
And then in 2006 and 2007, Hiltner built his house. And as part of the design of the house, this is trial exhibit 133. and then also it's in 139, I believe. This grading and drainage plan. And then there's Trial Exhibit 144, Michael Johnson's plans. They show that these parties recognized that there had to be access off the shared driveway to get to Bartlett's lot. And if you read this, it says this is an easement right of way for Lot 2.
And
Gerald
what-
Graham,
And what exhibit number is that?
this is Trial Exhibit 133, and it's also within Trial Exhibit 139. And then Trial Exhibit 144 is Mr. Johnson's plans. Now, what happened at that time is Mr. Johnson was hired by both Dave Bartlett and the Hiltners. He designed two homes. He designed the one that was built for Hiltner, which the Dabrowskis purchased for only $671,000, a $1.2 million home, plus 5 acres, plus an improved driveway. Talk about profits. I think they're irrelevant. I agree with you. What does this country come to if you can't make a profit out of a business deal? But they bought this house knowing that there was in existence this easement.
But the easement goes right up against the house there? Is that the one that goes through the guest house? Is that?
Well, here's what happened, and the testimony at trial showed this. Here's what happened. I don't know if that'll stay, but probably not. Okay. Here's what happened. The testimony showed that at the time the houses both were designed, the parties recognized that the easement would come this way but cut the corner of this house. Because of the difficulty of the building sites on this property, now you have to understand, this property is hilly, mountainous, rocks, boulders, everything around. To the south, there's a huge mountain. To the west is, for as far as you can see, is state trust land. The parties realized this, and they said, how are we going to do this? Because this is the only place we can really put this house as it's designed. So they agreed that Jerry Graham designed this roadway here for access, ingress, egress, access, and utilities, and a shared utility site here, so that both parties could get, or so that Mr. Bartlett could get access to his lot over the shared driveway. So they modified it a little. Instead of this part coming over here, he moved it a little bit. That is this is the modified express easement, as you can see here. All he did was move it slightly so that that could accommodate the Hiltner guest house. Everybody was fine with that. It got built that way. Bartlett didn't build his house because he ran out of money.
Before they built that house, is that the only building envelope on that parcel?
Well, pretty much, based on the topography. I mean, obviously, if you want to spend substantial amounts of money to dig out a site, you could do that. But then again, you have disturbance issues. This particular home sits, this is a low spot here. It sits below this area up here, so you drive down to it. This is a low spot. So any easement, like the slider easement they're complaining about, that would come this way, that the court said we're entitled to have under the private condemnation, they can't see it. It's all smoke when they say it's a big deal and it's going to cause all this damage. It's only 5,300 square feet of a strip of land. Anyway, getting back to, do you have any other questions about this?
No, but your visuals were helpful. Thank you.
You're welcome.
If you could, where is the proposed easement that they're suggesting they prefer?
Well, I don't believe, let me see here. No, Graham 1 or 2 is not on here. I do not have those, and mainly because they're really not feasible because of the amount of disturbance. Now, again, what the court has to understand is the topography. I can give you an idea of where they would be.
You need to put it back on the other. I
Yeah.
can't see it.
Okay. Put it up here?
That'll work.
All right. Okay, this is upside down from the other ones. But Graham, let's see here. Graham 1 and 2 would start down here somewhere. They'd start on Mr. Anderson's property. Now, he's already said he would not give us a disturbance easement for either Graham 1 or Graham 2. One would come up along this drop-off here and then cut over. The other one would be a little bit more gradual here. But all of this area is heavy rock and cliff and all that kind of stuff. You'd have to get a disturbance easement from Anderson on both of them, so they're really not feasible. And if you tried to construct them, they would be substantially expensive. This is the slider easement. It avoids all of this stuff and comes like that. And this to here is only 5,300 square feet. So, anyway, getting back to the modified express easement. That they say merger occurred. The trial court agreed with them. We say merger didn't occur because you can't have merger until you have a separation of the estates and then putting them back again. You can't have merger, and we've cited a bunch of cases on that. We've cited restatement law on it. In other words, this easement was created in 2000. It was not needed until Bartlett separated ownership of these two lots. These two lots were owned by the same person from 2000 until Bartlett separated them in 2005. Both of these lots, through every transfer, always went to the same person. So we think that merger should not apply. Now, if you agree, we go home. That's it. Because at that point, we have an easement, and the parties are pretty much told this is what has to be done. Now, if we have merger, and you say there's no easement,
And under that scenario, there's no compensation to the Dabrowskis?
that's true. There's no compensation because it's incredible that they say they didn't know about the easement because it was on their title report and on their title policy prior to them buying the property. I mean, how can you say they had actual notice? Plus, it was a matter of record. Didn't a real estate agent or the title company tell them? Anyway, if the modified express easement has merged, there's another way we get to the same route. And that is an easement, a servitude by implication. Because the law says it's implied that even if their merger occurs, once it's split again, because he needs access, we imply it goes over the path of the prior easement. Now, if you find that doesn't happen, we have an implied way of necessity. And an implied way of necessity is where there's some criteria that has to be established. Number one, there was a common ownership, then there was a severance. Number two, severance. Number three, because of the severance, a need arose for access.
And in reading the cases, most of the cases that I was reading, that the seller, it's not the seller. The seller isn't saying, "Oh, I forgot to keep an easement for myself." It's the buyer.
That's correct. Most of the cases are like that, but there is.
Do you have just a site? Give me your best case that's the other way.
I think most of the other way is in the restatement, Your Honor, and it might be Bickle versus Hansen, but I don't want to be tied to that because you are right. Most of the cases are that way, but there is language in the restatements of servitudes that we've cited in the comments that say it can go either way.
In the third restatement, but that was different than the first restatement, right?
The first restatement, the third restatement has a lot more in it than the first restatement. And the first restatement, there may be some contradiction in the first restatement. But what we cited to you, I believe, was the third restatement. And in those cases, there's an applied way of necessity. Now, Mr. Gottlieb was talking about intentionally waiving it. Well, the restatement law and the case law, and Bickle included, says that there has to be clear evidence of an expressed intent to waive or to landlock your property, to waive your rights to access to your property. We don't have that here. We have just the opposite. There was no evidence at trial that showed that Mr. Bartlett intentionally landlocked his property. I think Your Honor brought this up. You know, where's the evidence of that? Just because he forgot, it was probably negligent. Yes, but he also believed that he had access over the route of the 2000 modified express easement, because he testified that Jacob told him, you have access this way, not up my driveway at the time. That was Anderson's lot was owned by the Jacob Trust, a different entity. And Hiltner, Mahone, and Bartlett all knew that. And even Jerry Graham and Michael Johnson knew that. Jerry Graham was an engineer, and I think he's a surveyor, or has surveying in his business. And Michael Johnson was a home designer out in Cave Creek for a long time. There's your notice. He knew that he had it. Now, one of the things I want to touch on is the court allowing the Dabrowskis to submit post-trial evidence of damages. Well, I think we briefed that pretty clearly, and I think that the Dabrowskis really didn't refute any of the law we cited, but the law is in a condemnation case, in private condemnation, the condemnee has to present evidence of damages. If they don't do it, they don't get them. And in this case, they tried to bifurcate the trial shortly before trial, and the judge denied them. Said you have to, everything goes in, or you forever hold your peace, basically. They didn't submit any evidence of damages. We did, to be safe. We came up with a formula that showed the severance damages for that 5,300 square foot piece of slider easement would be between $6,500 to $7,800. And I think my time is up.
I have one last question.
Yes, ma'am.
Has your client ever tried to get an easement through the state trust property? And is that a viable way to access his property?
It is not a viable way. He's not tried, but it's not a viable way, because if you look at trial exhibits 147 and 148, those are aerial views, and as far as one can see through the state trust property, it goes on, and there's no access to it. There's no public road. Not showing. It goes for miles. In the south, there's that big one of the Seven Sister Mountains.
Okay. Thank you.
Thank you.
I'll try to touch on everything. You asked the question about Gram 1 and Gram 2. We cite to it in our brief, but it's index of record 242. There's an exhibit by Peter Vasecki. He was the Dabrowski's expert, and he has some nice graphics of the various easements, and there's discussion in that filing on the easements. That's index of record 242, the Dabrowski's motion in support of compensation. Mr. Alvarez began his argument by making a number of statements that the 2003 easement couldn't be constructed on. The trial court never found that. If you go back and look at the findings of fact, and Mr. Vasecki clearly testified, he was deposed in the case, he had pre-trial declarations, and he testified at trial that he could identify with reasonable certainty and believed it could. And so there was clear testimony from the plaintiff's expert that it could be constructed on, and the trial court never found that it couldn't. So I just want to point that out. Secondly, there was you were asking about the 0698 easement, the express recorded easement. You were asking for a site. That easement was found by the trial court to have been extinguished by merger 3 different times prior to 2000 and 2005.
Is that the one, which is the one that your client initiated the litigation over to?
That is the same one. It goes through the Dabrowski's home, their guest home. That's the express easement that the court found was extinguished by merger 3 different times. And just to briefly touch on that, Your Honors, the law is pretty clear on merger. When the lesser and greater interest are owned by the same unity of ownership, the interest merges. So there's no exception here, and it merged multiple times. And so I don't think there cannot be any exception to the fact that the express easement merged. 0698. Mr. Alvarez showed you the drainage civil plans to try to show there was this shared driveway plan. Hiltner and Mahan both were not present at the trial. There were no pretrial declarations or any evidence showing this. Mr. Johnson was the architect for both parties. He testified he was not aware of any agreement between Hiltner, Mahan, and Bartlett. None of those civil and drainage plans were recorded, or no documents were recorded, so there really wasn't any kind of competent evidence to make a showing as to Hiltner's or Mahan's intent here. As to the implied way of necessity, Your Honor, you're absolutely right. I could not locate any precedent where somebody was awarded what's called an implied reservation by easement in a case like this. And the trial court cited in her findings of fact and conclusions of law, she cited to Section 2.15 of the Restatement of Servitudes, which talks about you get an implied way of necessity unless there's contrary intent. And then she found that there was no implied way of necessity, confirming even the trial court's impressions and conclusions that one was not warranted here based on the circumstances. And then finally, Your Honors, as to the disclosure argument, I mean, the trial, it was a 2-day bench trial. The gravamen of the litigation was over access. They were seeking access under a variety of theories. Parties did their best. Both sides didn't disclose. Evaluation experts. There were numerous outcomes that could have transpired. The trial court recognized that once she made her ruling, and then sua sponte, she ordered supplemental briefing. We complied with her directive. None of the cases Mr. Alvarez cites to states that the trial court doesn't have any discretion to order supplemental briefing. The judge granted Bartlett's attorney an extension to hire an expert, submit briefing. He subpoenaed the file of the plaintiff's damage expert. He could have taken depositions, could have requested a hearing. None of that was denied, so we just contend there's no error.
Before you sit down, I do have a question I'd like to ask. Do you agree with Mr. Alvarez that Dabrowski's title report indicated there was that easement?
Which one, the 0698?
Yes.
I believe,
Any easement number 1.
Yes, I believe the title report did indicate 0698, but again, that's not an exception to the merger doctrine.
But you just agree that it was there. That was my question.
Yes, yes, Your Honor. I believe it did. The title report did indicate.
All right, thank you.
Counsel, thank you for your arguments. This matter will be taken under advisement, and we will have a written decision in due course. We are at recess.